Hello, everyone. Welcome to UK Office of Technology Commercialization's October webinar, Everything You Need to Know About Agreements. A few housekeeping items. Just wanted to let everyone know we are recording and we will send out the link from YouTube as soon as that video is available. And we also have live captioning enabled, so you can also do that if you need it. And we're going to start the webinar. I'm happy to introduce the Senior Associate Director for the Contracts team in the Office of Technology Commercialization, Eric Caslin.
All right, thank you, Jackie, and thanks for joining everyone. As Jackie mentioned, I head up the contracts team in the Office of Technology Commercialization. And let's go next slide, please. Quick introduction to our contracts team. In addition to me, we have two senior contracts coordinators, Ali Yankee and Natalie McCormick, and together we handle all contracts for the office. And these include negotiating all license and option agreements, as well as other agreements relating to intellectual property and collaborative research agreements, as well as execution or assisting with compliance of these agreements following execution. But the bulk of the agreements we handle each year, volume-wise, are what we refer to as transfer agreements. And these transfer agreements will be the focus of today's webinar. Next slide, please. So transfer agreements are needed in a few different situations. Anytime there's going to be a transfer of confidential information, confidential data, or proprietary tangible materials leaving the university. Those proprietary tangible materials are typically biological materials such as mice, plasmids, or cell lines. So there are three types of transfer agreements. Non-disclosure agreements are going to be used for sharing or receiving confidential information. Material transfer agreements will be for receiving or providing, sharing with another researcher the tangible materials, and then finally data use agreements, and these are for receiving or providing to another confidential data, particularly data derived from any human subjects. Next slide, please. So you can see from this slide, last year alone we did over 1,200 transfer agreements, and each year it seems to be with respect to each of these types of agreements, an increasing number that we're handling, particularly as Ali will discuss in more detail later, the data use agreements. And so next slide. All right, and with that, I will turn it over to Natalie. Natalie is going to cover NDAs, as she handles all NDAs for the office. After that, Ali will cover material transfer agreements and data use agreements, and then at the conclusion, we'll be glad to address any questions that you might have.
Thanks, Eric. I'm Natalie McCormick. I've been with the Office of Technology Commercialization since August of last year, so a little over a year with the university. I came from private practice. I was a practicing attorney for over 10 years with contract negotiation experience, primarily focusing on property rights, real estate, and financial services, as well as general civil and corporate law. So I'm going to talk about NDAs today, and I'm sure many of you are familiar with the terms non-disclosure agreement or confidentiality agreement, but what exactly are those transfer agreements, or NDAs as we like to call them in our office? We'll talk about what NDAs are used for, why we should use them, what information you'll need for a request, and then of course, what to do after your NDA is signed. So the first slide up is non-disclosure agreements in general. So what is an NDA and when is it used? An NDA is a binding contract that establishes a confidential relationship between two or more parties who want to have private, non-public discussions and share proprietary information, collectively, confidential information. NDAs can be mutual, with both parties sharing information, or they can be one way with only one party sharing information. We use NDAs to talk to a specific party about a potential collaboration or research project. We shouldn't be, there should be no funded work under an NDA. There should be no work or research that could result in an invention or creation of intellectual property under an NDA. The NDA is what I like to call the first step in fleshing out your collaboration with the other party. So the reason the university uses NDAs is to ensure that there are sufficient protections in place before you share any UK confidential information with another party. If you have confidential information and you disclose it to a third party without an NDA, you could potentially expose yourself or UK to liability. If you don't have an NDA and you disclose a potentially patentable invention or discovery that hasn't been filed or protected with the US Patent Office or another patent office, it could likely be considered a public disclosure, and then your ability to obtain any patent protection could be lost. Our NDAs essentially require all the parties to take reasonable measures to keep information disclosed under the agreement confidential, and it prohibits the parties from disclosing it to unauthorized third parties or using it in an unauthorized manner. The idea is we want the confidential information to only be used by those who want to use it, and then only by those who you want to use it, and then only for the purpose you want it used for as a researcher within the university. So now that we've talked about what an NDA is, what it's used for, why we use them, let's talk generally about what you need to prepare an NDA and the terms that were generally included in an NDA and agreement when you come across one. So what information do you need for an NDA? Do you want to make a request to our office? You can do so by emailing me. If you forget who handles NDAs, contact anyone in our office. We'll make sure to get you to the right person. We also have a fillable NDA request form on our website, and then you can complete and email that to us as well. When you make an NDA request, there is specific information that we need to draft the agreement. And then, of course, we'll follow up with any additional questions or information that we might need from you when you make that request. Typically, we need the name and the address of the other party, if you have it, the name and email of your contact person, a short description of the topic of discussion, and of course, any inventions you wish to disclose or you have disclosed to our office. We want to know the reason for the NDA. It's the purpose of the agreement. We ask our researchers to specifically provide us with a topic and a purpose, as it's our practice to tailor our research NDAs to the research or collaboration topic so that all parties are clear what is covered under the NDA, and we can make sure UK confidential information is adequately addressed. The estimated time period you plan to share information under the NDA, if you have that, you may not have that information, and we typically recommend 1 to 3 years for this, and we can always amend the NDA at a later date. We have a standard NDA template that we prefer to use when negotiating NDAs. Our UK form, especially if there is no edit, will allow you to begin sharing information sooner. If the other party prefers that we use their NDA format, we can certainly do that as well. We'll just review that NDA for necessary edits that would be needed from the university standpoint. Typically, the terms that you would find in an NDA are, of course, the parties to the NDA, the definition of confidential information, how to inform the other party on what information is confidential. You'll need to know the term of the agreement, how long the parties share confidential information. You'll see the confidentiality period, which is how long the parties must keep that information confidential. You'll see instructions on returning or destroying confidential information once your discussions are over or the agreement is terminated. And then, of course, there are various other standard provisions that you find in an NDA, such as how to amend the agreement. The signer is authorized to sign the NDA for the university. One other thing is, as for timeline in negotiating NDAs, the NDA shouldn't be a controversial document or take long to negotiate. There are a few terms that UK as a public university cannot agree to that other companies do like to include in their NDA. Some examples are governing law, UK can only agree to the law of the Commonwealth of Kentucky, or indemnification. The university can agree to indemnify the other party for their attorney's fees or something like that. When those provisions do pop up in the NDA, it may delay or take some additional time in negotiating. But for the most part, the NDA should be a pretty smooth process in getting in place. And next slide, please. So now that we have talked about what you find in an NDA and what you would need to do to make a request to our office, you want to talk about what happens once the NDA is signed. So good news is, once it's signed, you can start your discussion. If you're the primary contact for the NDA, you can start sharing and providing your information to the other party, and you can share it with other UK employees if they are permitted to receive it under the NDA. Something important to note here is that if you must share the confidential information with other university employees, all university employees, whether faculty, staff, or grad students, should be told about the NDA, that confidential information being shared is confidential, and that they are bound through their employment to maintain the confidentiality of that information that they learn. If required under the NDA and feasible, make sure any UK confidential information you provide to the other party is marked confidential. An example of this would be by adding confidential on each page of your document, stamping all confidential information confidential, as well as placing confidential in your email subject line. You want to respect the NDA. Only use the confidential information for the purpose that is specified under the NDA. Review the terms. You can always reach out to our office or UK Legal for any clarifications or questions regarding your responsibilities under the NDA. You want to keep that information confidential. You don't want to disclose the information to anyone else unless they're specifically permitted to receive it under the NDA. You want to protect and keep that information secure. This is where you use common sense. You want to store the information in a password protected computer or file, lock it up in a file cabinet or a room with limited access, or when discussing information with another permitted employee, do so in private. And if you discover that confidential information has been accessed by someone unauthorized to have that, notify us immediately, your department, UK Legal, and we can take the necessary procedures to prevent further access or exposure of any of that confidential information. So some final thoughts and friendly reminders as to NDAs before I turn it over to Allie. When an NDA is needed, we can use our template or we can review the other party's NDA form. Companies routinely require NDAs prior to discussing confidential information, so feel free to ask them whether one is needed early on. Anytime you have any questions about an NDA, you can reach out to me or everyone here at OTC, and we're always happy to help. We do know that sometimes NDAs can be urgent, and we would ask that if you know that it's going to be a time-sensitive NDA, that you connect us with your project as soon as possible so we can help it get that NDA in place for you. And as a very final note, I want to mention briefly clinical NDAs. As you know, I handle all research NDAs for our office, but we are in partnership with Jessica Heskell from UK's Center of Clinical and Translational Science to assist us with review of our UK clinical NDAs. They're still maintained with our office, but Jessica does help facilitate execution of those. So if you have an NDA, whether it's for research or clinical, contact me, contact Jessica Heskell if you worked with her before, and we'll make sure that the appropriate person can assist you in getting that NDA in place. So I'll turn it over to Allie for MTAs and DVAs.
Great. So as Natalie said, I am Allie Yankee. I have been with the Office of Technology Commercialization for a little over 5 years now. I was brought on to do transfer agreements. And so I've handled NDAs, MTAs, DUAs, and I now handle other agreements for our office, like license agreements, option agreements, IIAs, that kind of thing, as well as material transfer agreements and data use agreements, which I'm going to talk about today. So MTAs, material transfer agreements. So when do you need an MTA? Anytime that you are sending material outside of the university, you must have an MTA in place. These are going to be used for various reasons. You're going to be able to protect your material. You will be able to limit what the recipient can do with your material. You can limit the time frame that the material can be used by the recipient. And you can limit things such as liability for that's from the university side. A big issue for our researchers would be publication. So if they want to limit publication, you want to include either there must be a joint publication. That's something that we look into. And we also talk about how to cite our material providers in a publication. All of those are important terms for an MTA. So while they protect the researcher, they also protect the university. For example, if you're sending a mouse to another facility and unbeknownst to you, the mouse is infected with disease, it goes to, for example, the University of Alabama, and it infects their entire mouse population. There is going to be liability for the university there. However, we can take our MTA and use it to lessen the liability on the university. It's important when you have an MTA to know exactly what you are sending. So one of the top questions I'll ask when someone says, I need to send material to an outside institution, I'll say, what are you sending? Is it going to be a biological material? Is it chemical? Is it like a plant, for example, something we sent? Animals? I've sent a variety of animals across the United States and to foreign countries. That's another issue, is what can the recipient do with the material? So we'll have all those restrictions in our MTA. How long can they use it? Well, that'll be in the MTA. And then we'll go on, and if the issue becomes, if you don't have an MTA, what happens? Then that researcher, that's the recipient, can use your material for any reason they would like. So they could use it in, for example, human testing, which is something we would like to avoid. And on the flip side, if you are receiving material, the majority of the time you're also going to have an MTA. However, in that situation, the MTA would come from the provider of the material. So if you have a request for an MTA sent to you by an outside institution, please send me that MTA and I will work with you to review the terms, make sure you're comfortable with the terms and you can meet the terms, and then we will make sure that your research matches up with what they're allowing you to do with the material. For all MTAs, they are signed by my office, and we can also put in terms such as shipping, for example. So each MTA is going to be unique to your situation. Now, while each MTA is unique, there are different forms that we like to use. So on your screen, you'll see common MTAs that our office uses. They've all been pre-approved by UK Legal, and most of them can be accepted by an outside institution with little to no negotiation, making transfers extremely quick. So the first MTA you'll see on the screen is the UK template. This is something that has been drafted by my office alongside UK Legal. This MTA has the most flexibility. So if we are sending a material that we have to be extremely restrictive on, if we're sending the material to someone who is a company or outside of the United States, we will most often use this template. It allows us to tailor the terms to the specific material, the specific project, and we can also add additional terms. This MTA addresses the time frame, it addresses the use of material, it addresses publication, it also addresses ownership of any new inventions. So if you send your material to an outside institution and they make modifications, they make unmodified derivatives, they make progeny, any of those things, UK would own those. So we want to make sure, and under the typical terms of an MTA, so we want to make sure all of that is listed so that we can establish ownership of anything going forward. The second MTA on your screen is the is the simple letter agreement. This is a template from the NIH. It makes transfer of materials that don't have a lot of restrictions, pretty common materials, very simple. Per the name, it is 1 page long. We can transfer any material under this, especially if we are transferring to or from the NIH. They like to use this template. There's not a lot of restrictions, pretty similar to most MTAs. They have, you cannot use any material in human testing. You cannot transfer outside of the recipient at the university. And there is liability language. The third MTA on your screen is the Uniform Biological Materials Transfer Agreement, or the UBMTA. Most individuals at the university who have completed an MTA have seen the UBMTA. And the reason for that is the agreement was actually drafted in 1995. So it's been around for a very long time. And the terms have been agreed upon by many institutions in the United States, research institutions. So we can use these terms and without any negotiation. All we have to do is fill out this implementing letter, which is the first page you see on your screen. Within the implementing letter, it'll say who is the provider, who is the recipient, as well as the provider researcher and the recipient researcher. It will address the actual material. It will address any shipping and handling fees, and it will address the term. Then there's the UBMTA actual terms, which are available online, or if you would like to see those, I have a copy as well, that have the actual MTA terms, which go into restrictions. It goes into ownership of any new inventions, providing the material beyond the actual recipient. All of that is talked about in the UBMTA terms. So if you are sending material outside of the university, chances are you're going to use one of these forms. If you are receiving material, you might be likely to see the simple letter agreement or the UBMTA, because many institutions use these templates. If you have a separate agreement that you've been sent from an institution to receive material, please send that to me. I will negotiate that, and I will have that agreement signed on behalf of the university by our office. So if you have material that you want to send, or you're going to be receiving material and you want to kind of get ahead of any template that might come in, here's information that you can send me, and I can help you either draft an MTA, or I can help negotiate an MTA that comes into the university. We'll need to know the name and the address of the other party. A link to their website is always helpful as well. So if you just have your colleague at another university and you don't have any information about their Office of Technology Commercialization or whatever it might be called at their university, that's fine. But if they have a link to the website, I can go in and I can find that person. The name and the email of the other party's designated contact person. Again, I can find this if you don't have it, but your colleague probably has that information. A short description of the project and how the materials will be used. This is extremely important when we want to limit what a recipient can do with our material. So this prohibits us from sending material that maybe doesn't have a patent yet, or we consider confidential, to an outside organization, and then that organization being able to take that material and do whatever they want. If we know exactly what they're going to be doing with the material, we can limit to that specific project. Ownership of materials is very important. So this is extremely common when we see, I want to send a cell line to a colleague at a different institution. Okay, who owns the cell line? So if you purchase this cell line, or if it was received from another institution, UK might not own that material. So we can't exactly send the material to a third party unless we have permission from the original owner. This is something I can help establish. So if we receive the original material under an MTA, sometimes the MTA provides for how we can send that to a third party. Perhaps we need to reach out to the original provider and just get an email authorization. They might want to do their own MTA with the new third party. All of that I can help you figure out before we send the material. And then finally, any time constraints for shipping. Here's an example. You have a mouse. A lot of the times in the summer or in the dead of winter, we don't like to send live animals because the concern is the temperature outside. How are they being shipped? All of those things are important to know up front. We don't want to take it. We don't want to start an MTA in maybe March when we have plenty of time to send live animals that for whatever reason takes for a long time to negotiate. And then we're sitting in the middle of July. We can't send the animal at that time. So it's important to know, what are your time constraints? What are you shipping? Who are you shipping it to? On that line, the next agreement I'm going to talk about are data use agreements. So data use agreements and MTAs are fairly similar. All of these kind of agreements are similar in the fact that you are transferring something into or outside of the university. We have the same rules as kind of Natalie mentioned. There are governing law, indemnification, all of these things play a role in each of these agreements, and we have to follow the same rules in all of them. Now, the data use agreement and the MTA are very similar, and sometimes we can even transfer data under an MTA if it's completely de-identified data and there's not a ton of security requirements. We can send it with an MTA. If you've sent biological materials, perhaps in the past, you will see that if you had corresponding de-identified data to send with, for example, tissue samples, we can send the tissue samples and the de-identified data together in an MTA. Pretty easy to do. Now, when you start having a data set that has maybe a limited data set, or it's purely a data set, or there's health information involved, you're going to need a DUA. And the main difference between a data use agreement and an MTA are going to be the security requirements. So when I first started a couple of years ago, I was told not to worry about data use agreements. We only do a couple a year. And so, and they're very similar to MTAs is what I was told. So I started doing the job, and we go from, so I started in 2017. So we went from 13 to 36 the first year. And then the next year we did 73. So my first full year here, we did 73 data use agreements when I was told not to worry about data use agreements. Last year, it's not on the screen, but we did 154 from a previous slide. That's a lot of data use agreements. It's a lot of data sets that are being transferred into and outside of the university. So we can't really use an MTA for all of these data sets. So a data use agreement, DUA, what makes them different? Why can't we use an NDA or an MTA, for example? DUAs, or sometimes they're called DTAs, data transfer agreements, govern the transfer of data sets between institutions. The biggest difference, as I mentioned, are the security requirements. So the university has, along the same lines of a couple of years ago, data security is obviously important. You don't want your social security, for example, number to be stolen. Everybody kind of knows that. A couple of years ago, we had a relatively low deductible on data security here at the university. And in the past year, it's jumped to almost 10 times the amount of what it was 3 years ago. So data security has become extremely important. And alongside that are data use agreements. Data use agreements are used to transfer data for research purposes. So if you want to transfer data, for example, you're in the hospital and you want to transfer data to an outside organization for business purposes or for medical purposes that are outside of research, you do not need a data use agreement. You need to go to a separate office to handle that. If you are doing research, you need to contact us. You need a data use agreement. Some data use agreements or some projects have multiple data use agreements. So for example, we have a very large project at a pharmacy that has something like 48 sites where we are receiving data from all 48 sites. This is all de-identified data. So when it's de-identified data, some institutions do not require a data use agreement. UK does. In those situations, we can set up a template data use agreement that all those institutions can use, so that if your project has data sets from multiple institutions, all of those institutions will have the same set of rules. This is really important when it comes time to publish, and you have to go back and figure out, okay, this data set had these publication rules, but this other data set has a separate set of publication rules. We want to avoid that so we can use the same template. When dealing with personal data, so whether that be For example, today I had a call about survey data where the participants, it was not patient data, it was not clinical data, but the data was names, birth dates, addresses. That's just going to be personal data versus healthcare data. Both are extremely important to protect. You have to have a DUA in place with the university. On your screen, you'll see the FDP DTUA guidance chart. So this is a chart that can be found online. I can also share this with Jackie at the end. That kind of goes through when you need a data use agreement and what type of data use agreement you'll need. Because the university bases the type of data use agreement you need on the type of data you are sending. So if you are sending de-identified data, you're going to have a different set of terms than if you're sending a limited data set or full PHI. Another form that I can share with Jackie to kind of add on to the email that goes out later would be a human classification tool. This is just a one-page PDF, and it talks about the different data elements that you are sending and whether they qualify your data set as full PHI or PII, if it's not health data, versus a limited data set and then completely de-identified data. So once we've determined the type of data that you're sending, we can focus in on the specific template that you need to use. After that, we need to know the duration. How much or how long can they use the data? The typical duration for our data use agreements here at the university is 3 years. However, we can shorten that or we can lengthen it depending on your specific project. Project specifications and restrictions. This is very similar to what I talked about with an MTA. We need to know either if you're receiving data, what you're using the data for, or if you're sending data, why are you sending the data to this recipient? What can the recipient do with the data? Especially if it's patient data, we want to make sure that it's very restricted and very tailored. Publication requirements are very similar to an MTA. If you're sending data to an outside institution, you want to make sure that if they publish, that you are cited as at minimum the provider of the data, or if you're working with them as an author, depending on the scientific requirements for that publication. And we also want to make sure that we see the publications before they are published. We can stipulate how many days in advance they have to give UK notice of their publications as well. So we can make sure that there's nothing that is confidential that is included in their publications. Formatting instructions are something that are specific to data use agreements as well. We want to make sure we send or receive the data in a format that is that meets the requirements for the project. So maybe we are just uploading to RedCap, but maybe we need to send an Excel sheet. How are we going to send the data? How is it going to be uploaded? All of that is stipulated in a data use agreement. Disposal instructions are very similar to an MTA. Once we are done, the recipient, or UK, if UK is the recipient, has completed their project and they no longer need the data, are we supposed to destroy the data? Are we supposed to send the data back? As many of you know, if you're a researcher, there are requirements on how long you were supposed to keep a data set after you publish. All of that can be in the disposal instructions. Security requirements are extremely important, as I mentioned before, as far as liability for the university. And we just want to make sure if we are collecting data, it would look bad on the university. And if we collected data from a bunch of participants in a study and then all that data got leaked, no one is going to want to participate in our studies anymore if we cannot control the data once we have it. In addition, if there is a security, so if we send data out, the liability language that's next plays into this. If we send data to a recipient and they have a data breach, we can limit the liability on the university and put more of that on the recipient. And we also have requirements about how they have to notify us, how quickly they have to notify us if they have a security breach. So finally, when do I need a DUA or a DTA? If you are sending data, you must have a data use agreement, whether it's de-identified or a full PHI, PII, you must have a data use agreement. If you're receiving data, chances are you probably are going to need a DUA. If it's a limited data set or more, you must have a DUA. Finally, the template you see on the screen, this is the FDP template that I previously talked about. We use this template a lot because similar to the UBMTA or the simple letter agreement, the terms are set. These terms were developed by the Federal Demonstration Partnership probably 3 to 4 years ago. And the Federal Demonstration Partnership is an association of federal agencies, academic research institutions, including UK, and research policy organizations. So they all work together. They noticed, similar to what we've noticed, that data use agreements were being used more and more. We had to have terms transfer data outside of an MTA or an NDA. And in order to do that in a streamlined process, they came up with the FDP template. The template, the main terms of the agreement do not change. There are 3 separate attachments. Attachment 1 addresses the specific data and the specific project. Attachment 2 actually changes depending on the type of data you have. And then attachment 3 talks about collaborators. So for example, today we were sending, when I had the phone call I was talking about previously, we were sending out data, but we did not want the recipient to share that data with anyone else. So we could tailor that in attachment 3. Sometimes though, we have situations where maybe there's a large project. The project I talked about out of pharmacy had a steering committee made up of researchers from various universities and institutions. They have to tailor their attachment 3 to allow for the steering committee to have access to all of the participants' data. That's all done in attachment 3. We like to use the FDP again because we don't have to negotiate the terms, and there are many institutions that use the FDP. So sometimes when we're receiving data, we see this FDP template, which is great. This is kind of our template for the university. It has been approved by legal, our office, risk management, and privacy for the hospital. So to end that, how do I get an agreement? Our contact information is listed on the screen for MTAs and DUAs. It's my email. If you think you need an agreement, but you're not sure, please feel free to send me an email. Natalie as well. Call us up and we can walk through your specific project or specific scenario and determine what type of agreement you need. For non-disclosure agreements, you're going to reach out to Natalie. If it's a clinical non-disclosure agreement, you'll reach out to Jessica, and both of their emails are there. And then finally, any questions?
Thanks, Allie, so much. We do have some questions from our participants. And I just want to get our other speakers up here so they can also answer questions. Sorry for the delay. Okay, there we go. Yes, we have a few questions here. One is, do I need an MTA for mice that I buy from a platform like Jax or cell lines from ATCC?
Yes, you do. So we have created agreements with, for example, ATCC. We have a master agreement that we have with the university and ATCC. However, we have to add individual researchers to that MTA. So once you go to request mice at ATCC, it'll ask your institution, and then it should send you an MTA. Sometimes it sends them directly to me if it's put in with a UK-wide email, and we will sign that MTA for you, and we'll get you listed as a researcher under the University of Kentucky. Jax is similar in that they send us the MTA. We don't have a master, so we have to sign an MTA each time, but they're all very similar. And the reason we can't have an MTA with Jax is because the mice come from different providers. AdGene is another, where when you do an AdGene order, it will automatically send me an MTA for me to sign. The MTAs are pretty standard. There are a couple different variations of that MTA, but all of those come directly to me, and I can approve those so that your order can be processed.
Thanks, Sally. We have another question. Do you have any additional or specialized procedures in place for NDAs, MTAs, DUAs, or DTAs with partner organizations, individuals based outside the US? If so, are they screened for any restricted entity list exclusions, et cetera?
Yes, that's a great question. Increasingly, important for us to remember when sharing information, data, materials, anything outside the U.S. For us to contact our export control officer within OSPA, John Craddock, I think is who that is, as well as sometimes UK legal, and this is increasingly important as well. So thanks for mentioning that, Tim.
And I'll note, just to add to that, especially when it comes to data, sharing data, whether we're receiving or sending data to the European Union, is becoming increasingly difficult. And the UK legal has gone as far as, if there are certain requirements in data use agreements that for the European Union, we cannot send or receive data because we cannot meet their security requirements.
Thanks, Allie and Eric. Another question, do I need an MTA if I have another agreement in place, like a joint research agreement between schools?
So that will depend on the terms of the joint research agreement. So this is a specific scenario where please reach out to me via email or give me a call. I can review the joint research agreement and we can determine if an MTA is needed.
Oftentimes that is the case too, when putting together a joint research agreement or collaborative agreement. Typically, these are put in place when we want to formalize a research project between one or more or two or more institutions, but there's no money changing hands, and oftentimes that will involve the transfer of material. So there at the outset, in addition to outlining how IP rights will be shared or who will protect any inventions by patent application and so on, we will also address any materials, at least that are contemplated at that time, at the beginning of the project, to be transferred from one to the other.
Thanks, Allie and Eric. Another question, what if I have already disclosed confidential information without having an NDA in place? What do I need to do?
It is. Oh, go ahead, Natalie.
I'll take it. So if you've already disclosed information, you want to contact us immediately about that NDA request and let us know what confidential information you may have disclosed, when you think you first disclosed it, and we can always work with the other party to get an NDA in place, and of course backdate that NDA to cover the confidential information that has been disclosed, so in order to adequately protect it. And then of course, anytime you have that, always feel free to reach out to us. We're happy to answer any questions and provide specific guidance.
This is true for materials and data as well. If you have transferred anything without first having a transfer agreement in place, please give us a call and we can work with the other institutions. A lot of the times, if it's another academic institution, they're perfectly fine with backdating an agreement. They have no issues because they would want us to do the same for their researchers.
Exactly.
Thanks, both Natalie and Allie. Another question, do I need a DUA if I'm sending my data in for a publication?
If you're sending your data in for a publication, probably not, but we can read the publication language and figure that out as well. So please just feel free to send me an email, let me know that where you're sending the data, and we can look into it.
Thank you, Allie. Another question is, I have an NDA with a company that just expired, but we still need to share information. What should I do?
In an instance like that, we can get in contact. If you send me an email, we can get in contact with the other party's contact and extend the NDA. If the NDA is already expired, we'll work to get a new agreement, and then of course tailor that agreement to be covered, so there's no time lapse in between the sharing of confidential information. If you know that the NDA is coming up to be expired, just reach out to me early on, and then we can do a simple one-page amendment to extend the time frame for sharing under the NDA. And I would say with Ally, that would be the same thing with MTAs and other transfer agreements in general. We can always amend those early on before they expire, or work to get a new one in place and make sure there's no lapse in coverage of the agreement.
Thank you. Another question, I received material under a previous MTA. Now I want to share it with a collaborator at another institution. Is this possible?
Most likely yes, but we need to look at the original MTA and see what the terms were as far as sharing the material. A lot of the times, especially if it's with an academic institution, the term will state that we can share material outside the university for research, non-commercial research purposes under a new MTA. So we'll just need to do an MTA that states who the original owner is. Sometimes we'll have to reach out to the original owner and get their permission to transfer the material to a third party.
Thank you, Ally. And we would have one last question. The company I'm working with already has an existing NDA with UK. Can I use that existing agreement?
I would say that depends on what kind of conversations you're having under the NDA. In the situation, as I mentioned in my presentation, is we like to tailor our NDAs to apply to the research topic or discussions that are being handled under the NDA. So if you have an existing NDA and the new conversations or new information you want to share doesn't relate to the purpose of that original NDA, we want you to have a new NDA in place so we can make sure every information is adequately protected on both sides of the line for both parties.
Thank you. Ally, Eric, Natalie, any last words you want to give our audience before we end the webinar?
I just
Thanks
want to
for
say
joining.
that, yeah, thanks for joining. But I just want to say that we are all very open to questions. So all of our contact information is on the website, and we are open to a phone call. We're all on Teams if you want to send us a Teams message. So I would much rather have 100 phone calls to figure out we need 3 MTAs than no phone calls and that material gets transferred without an MTA.
Absolutely.
Well, thank you, Ally, Eric, and Natalie for all this fantastic information. As I mentioned in chat, we will be putting this recording on the UK Innovate YouTube channel, and I will send that link along with the PDF of this slideshow and the additional information that Ally mentioned earlier, so that you all will have access to that. That will go out to everyone who registered for the webinar. And we hope you'll join us next month for our November the 3rd webinar with Christine Wilds, who will be talking about the new innovation training micro certification that we are doing. And you can go to the UK Innovate website to register for that webinar. Thank you again, and we hope you all have a great rest of your week. Thanks, everyone.
Thank you, Jackie. Bye, everyone.